Hello, everyone. How are you? Say, Shirin had something come up this morning, so we weren't able to do this call. We'll schedule again at our earliest convenience. I wanted to stop on and talk to people a little bit just so we understand exactly what you're looking at when it comes to the DOJ, website accessibility, and what's really transpired over the past month. So, to give you a little bit of history, in 2010, at an anniversary for the original Americans with Disabilities Act, President Obama suggested that websites should be included. So for the past 12 years, it's been a little bit of a gray area. Some states have created their own laws. Other law has been created by what's called case law. So basically lawsuits and what's transpired within one person suing a business over their site not being accessible. So the significance, in my opinion, from what happened on March 18th is the DOJ officially placed in writing that websites are part of the Americans with Disabilities Act. By doing so, they also reference WCAG. WCAG is the Website Content Accessibility Guidelines that are distributed by a company called W3C or the Worldwide Consortium. This is the standard that is used for other types and everything surrounding accessibility to make sure that all websites work for everyone, regardless of their ability or disability. This is a very strong point because states that have created their own laws have also referenced WCAG, the current version. So, where some people are saying this is confusing, nothing is really spelled out, it really isn't anything new. These are what case laws have been based off of for the past 6, 7 years when a lot of these lawsuits have transpired. So, it is fairly cut and dried, black and white, for those that work in accessibility to understand which guidelines you need to adhere to and which ones you may or may not adhere to. It kind of is the end of the wild, wild west, I would say, with regards to websites, with regards to individuals creating their own, and with regards to whom is creating websites as a business. It's going to really change the playing field and change what businesses do for with websites and how they promote themselves via the internet. Now, one thing that I want to keep everyone to keep in mind is a lot of times there's some confusion because there's different titles or chapters or different types of Americans with Disabilities Act that different businesses need to adhere to. Keep in mind that this is part of Title II and Title III. Title III is what's called or what refers to a place of accommodation. So that means anyone that conducts business with consumers. With Title III, there is no minimum of employees that you have to qualify for. There are some laws under the Americans with Disabilities Act that apply to employees under Title I that states a business must have 15 employees for them to be held accountable by these rules or laws. With Title III, referring to a place of public accommodation, there is no rule. There is no limit. So you can be a one person operation and you still have to adhere to the Americans with Disabilities Act and Title III. And that's where this falls under. So that's one of the biggest misperceptions that I see is people not knowing that they have to comply, that their website has to be accessible for those with disabilities. Um, Another one that we're seeing quite a bit in lawsuits in California and some in New York now is what's called like an overlay or a plugin. It seems as though those are targets for lawsuits. If you look at our website, you'll see a lot of lawsuits. Our companies are being sued with a quick fix on there. Um, you can see articles from Carl Groves, videos from Carl Groves that's been working in accessibility for a couple of decades, and his expert testimony with regards to these things. So, what I'm trying to convey to you at this point is just putting a little widget, a little thing on your website does not seem to protect you from being sued. It's almost being used as a target for those serial litigants and their attorneys to file lawsuits against businesses. So, the only way to make a website truly accessible is at the code level by someone that knows how to code in a little different language or a little slightly different language than what most websites are built in. So any of these websites that you're building yourself, you have to understand what codes need to be changed, how to change these codes, because to the best of my knowledge, I have not seen a website out of the box that you would want representing your business that will be truly and completely accessible, especially when you start adding content, when you start adding photos, when you start adding different things to the website that requires more coding on the backside to work for those with disabilities. So, what's interesting and going to see what happens from this point on is how much these lawsuits escalate and how much information is shared with local business owners. Typically, I would say in New York, in the last few years, there were probably on average of 50 or 60 website or businesses sued per month for website accessibility. We've had some weeks in the last month since this happened where there were over 100 lawsuits a week. So that's 4, 5 times the amount of businesses being sued. According to a report that read here in the last month or so, in the first 3 years that this has been a law in California, there were over 18,000 businesses sued under California's Unruh Act. So this is something businesses need to be cognizant of, aware of. Now, we've talked about some of the negatives. Let's briefly talk about some of the positives. Uh, Depending on which studies or numbers you're looking at, somewhere between 18 and 23% of people in the United States have at least one long-term disability. So a vision issue, a hearing issue, maybe they have MS or MD and they can't navigate a mouse. Maybe they have epilepsy. Maybe they have a cognitive issue. These are long-term disabilities. So if you're looking to conduct business via the internet, you're looking to attract customers, you really don't want to exclude 18 to 23% of the population from conducting business with you. Um, that's not to talk about short-term disabilities, environmental disabilities. You know, if you're in a loud area, that's going to be an environmental disability. A short-term physical disability could mean you're holding something. Maybe you're holding a child. Maybe you're holding something and you're trying to navigate your phone on a website to try and conduct business. So we have to make sure that websites are easy to navigate in any situation, and the consumers, your potential customers, are able to conduct business with you. So those are some of the things to consider and understand when, yes, you may have to spend some money to make your site accessible, but it should bring back more business for you and protect you from some of these serial litigants that are suing businesses with an alarming regularity. So I hope this was helpful. If you have any questions, please feel free to reach out. I just wanted to touch base a little bit and discuss the DOJ's adding of websites to the Americans with Disabilities Act, just so everyone's kind of aware of this. And we hope you have safe surfing and safe websites. Take care, everyone.